So welcome back, everybody. My name is Yael Ronen. I'm from the Minerva Center, and I have the pleasure and the honor of chairing the first regular session of the conference, which is entitled Overarching Principles. We have 3 speakers who will be speaking in the same order as they appear in the program, and not only because this is the order of their names alphabetically. So our first speaker is Professor Robin Geiss, who holds the chair of the International Law and Security at the University of Glasgow. Previously, he was Professor of International and European Law at the University of Potsdam. Prior to that, he worked as legal advisor to the International Committee of the Red Cross in Geneva and as ICRC delegate to the United Nations Human Rights Council. And Robin will be speaking about dual-use objects. From
here.
From here.
Oh. Thank you very much. Good evening, everyone. Well, first of all, warm thanks to the organizers for inviting me. It's always a great pleasure to be here. The panel is on overarching principles. My talk is on dual use. I'll kind of follow that sequence and start general and then go specific. A few general remarks on Article 52. I think 52 is pretty much for all purposes a wolf in sheep's clothing. So where's the wolf and where are the sheep's clothes? The sheep's clothing is here. Article 52 gives you the appearance of a very well-crafted, sophisticated legal rule with all its various components, a two-pronged test, military advantage, nature, purpose. So there are many thresholds, and all of this creates the appearance that, indeed, there are a lot of safeguards before anything turns a military objective. This is the sheep's clothing, I would say. The wolf is here. In reality, I think for all practical purposes, the test usually is much simpler, much more straightforward, and much more sweeping. If it makes an effective contribution to military action, and for most practical purposes, it does qualify as a military objective. It's not a conclusion I like, but I do think the limiting qualifiers, if any, that you find in 52 are not really very effective. So my quest is to look for more workable, more effective limiting qualifiers, if I can. Now, of course, I'm aware if I say if it makes an effective contribution to military action, then it is a military objective, is not an accurate reflection of the holy two-pronged test. And I know a lot of humanitarian lawyers are up in arms if I say that. The point, however, is, and I used to say it, and I do say it, and I would like the two-pronged test to be there and to work. It just doesn't. The point is, once you have evidence that something is making an effective contribution to military action, then it will be very, very, very difficult, and in 99% of all cases impossible, to reject that claim. If somebody can show convincing evidence that something is making an effective contribution to military action, then for most practical purposes, this qualifies as a military objective. At least it's very difficult for anyone who wants to reject that claim to really do that effectively as a matter of law. Now let's take a closer look at 52. I'm still on general remarks. First of all, the 4 criteria of nature, purpose, location, and use. All very well. The literature is full of filigree distinctions between what is nature, what is use, what is purpose, and so on. I wonder, does all of this matter? We're not concerned why something is making an effective contribution to military action. What concerns us, if it does. And if it does, I think it qualifies as a military objective. So we don't need these filigree distinctions. Perhaps we do need them for evidentiary purposes. I would agree on this, but for all other matters, it's really not all that relevant, whether it's use, purpose, nature, or location. And even, imagine, can anyone in the room come up with something that makes an effective contribution to military action on any other ground? Other than use, intended use in the future, not even present, location, or nature? I don't think we can. And these criteria were meant to be comprehensive. So what this is all about is to capture everything that makes an effective contribution to military action. You may not like it, I don't like it, but I'm afraid this is what the rule gives us. Secondly, if you look at the two-pronged test, in my view, the two-pronged test, so the 2 prongs are, does it make an effective contribution, and would its destruction offer a definite military advantage? I think this is asking the same question from 2 different perspectives. Does it make an effective contribution to the enemy? And would it offer to me, the attacker, a military advantage if I destroy it? For most purposes, this is asking the same thing, just from two different perspectives. And if you answer one of the two prongs with yes, yes, it does make an effective contribution to military action, how does it not offer a military advantage to the enemy if you destroy it? I really have difficulty in finding good examples. And even if, I mean, we're lawyers, we're experts in finding the hypothetical odd exception, yes, okay. But even if you find the odd exception where something makes an effective contribution to military action, and yet its destruction as such would not offer a military advantage to you, as a matter of fact, the military advantage does not even need to flow from taking this effective contribution from the enemy. It could be a ruse. You might be attacking a military object not because you want to take its effective contribution away from your enemy, but because you want to fool him. You want to have a ruse and distract him from where you're actually going to attack. So if the military advantage doesn't even need to flow from this thing making an effective contribution, how is the two-prong really an effective constraint? And this is my concern. Now, of course, as I said, we're lawyers, we're good with hypothetical odd exceptions. In the literature, there is no shortage of ostensible examples to prove that the two prongs would work. The examples you find in the literature are usually this. You have to square the circle and find a military object without military value. So the examples usually work around military objects by nature, a tank that is still 1,000 miles away from the combat zone. A fighter jet that landed in the Iraqi desert, now it sits there and can't be restarted. It's stuck in the desert. It's a military object by nature, but given that it cannot be used, or given that the tank is not yet in the combat area, so the example goes, this doesn't offer a military advantage in the concrete circumstances of the case. These are across the board, the examples you find. I have difficulty with these examples, because first of all, you could of course argue the situational requirement is not only about it's not only about the military advantage. You can already consider situational relevance for whether it makes an effective contribution to military action. So I would say, if the fighter jet is stuck in the desert, you either say it's not making an effective contribution to military action any longer, or if it does, then its destruction offers a military advantage. And again, for all purposes, practical purposes, it'd be easy for the attacker to argue its way around. Because you could say, okay, the tank 1,000 miles away from the hot zone of conflict is not there yet, but perhaps it's already now an integral part of the enemy's planning. And if you want to disturb the enemy's strategic planning, then that is a military advantage. So I really find it difficult to make much sense of these examples. And perhaps worst of all, I really could care less whether you attack a tank or a fighter jet. This is really not my main concern. My concern are objects that also serve civilian functions. This is what I'm really concerned about. This is dual use. This is what I'm going to do now. Dual use is in many ways a non-starter, because Article 52 and the customary pendant definition really offers a test to determine whether something, and that could be anything, civilian, is a military object. So there is no particular dual use objects as a matter of law. As a matter of law, everything, unfortunately, is in a way dual use. And I'm afraid that is a problem, because the definition, as I tried to show, is extremely sweeping. So I don't disagree with much what I say, but I'm quite unhappy about it, I should say. Okay, so if everything's dual use, as a matter of fact, we speak of dual use objects, and then we mean those objects that lend themselves, that are prone to military use. So we speak of an electricity grid, which usually serves civilian functions, but easily it's turned to military uses. But it's only as a matter of fact that we use that language. As a matter of law, everything is dual use. So let me highlight a few problems with dual use, and then I turn to a few tentative solutions. Well, let's take the easy case for starters. If a so-called dual use, a civilian object, is visibly making an effective contribution to military action, then its legal classification should not raise too many problems. This is a military objective. Even in this straightforward example, we can find some ambiguities that could turn out to be quite difficult. First of all, what is the object we are talking about? This is something that was raised in the introduction already, and it is a problem that we have difficulty in complex structures and so on to really delineate what the object is that we're actually talking about. If the sniper is on the 8th floor in a high-rise building, is the object we're talking about the apartment he's in? Is it the floor he's on? Is it the building, the high-rise building as such? That is a problem, and it's quite a basic problem, I would say. Another very basic problem that gets very, very little attention, I find, is what actually is an effective contribution. So we're concerned with standards of evidence, and I fully agree to that, but without knowing what it is that we want to prove, it's difficult to start talking about standards of evidence. What is an effective contribution to military action? Does effective mean significant? I would hope so, from a humanitarian perspective, but I'm not sure that's agreed for any matter. What is an effective contribution to military action? Could it be minimal contribution? Imagine a power grid, electricity thing. It's used in its entirety. 100% of its capacity is used to power the air conditioning system in a huge military compound. So 100% use of a military, of a civilian electricity grid power station to power the air conditioning system. Now, that's very extensive use, but I mean, the air conditioning system, is this an effective contribution to military action? I'm not so sure. Conversely, if the power grid was only used, the power station was only used by 5% of its capacity, but to power the most important communication facility, then clearly it would be making a very effective contribution to military action. And can we say that just because there is significant use of something, there's also an important and effective contribution? Because this is the actual test. We tend to look in practice, we tend to look for whether there is significant use. And that's our shortcut, so to say, to prove it. But what the definition requires is whether there is effective contribution to military action. The use could be insignificant, could be little, could be big. What really matters and counts, and this is much more difficult to prove because this is a secondary step, is whether there is effective contribution to military action. I find that all mind-bogglingly difficult. I don't see how you can make much sense of it in operations, other than simplifying it and just going by, is it effectively used, and then we qualify it. And that's a problem. That was the easy example, by the way. Let me turn to the problematic one, which is if a civilian object is not visibly being used to make an effective contribution to military action. Because if it's not visibly being used, then we turn on the purpose criterion. And the purpose criterion, whether something is their intended future use, is the most difficult and the most fuzzy of all these concepts. And in fact, the purpose criterion significantly broadens the entire qualification exercise. Now, first of all, the criterion of purpose is problematic because it's difficult to determine at what point it becomes sufficiently clear or sufficiently reasonable to assume that an object's purpose is to contribute to military action. That's a problem. It's also ambiguous, the purpose criterion, because we don't really know for whose or what purpose we're looking for. Are we looking for some kind of inherent purpose in the object itself? I don't think so, because that's very close to nature. That's an intrinsic purpose characteristic. Then distinction between nature and purpose really wouldn't make much sense. Or, as the ICRC commentary, I think rightly says, are we looking for something where a person, it's a subjective element, it's an intended future use, a person subjectively ascribes to the object? Is it, I think I'm going to use this building as my ammunition depot? Is this what counts? We have hardly any clarity on whose purpose is it that we're looking for. Is it the individual fighter? Does it matter what each individual fighter thinks he's going to do with that civilian object? Is it the military commander? Is it the party's purpose we're looking for? I don't know. I don't think this is much discussed in the literature. I think this is a glaring gap of unclarity. Whose purpose are we looking for to start with? And are we really prepared to say, I don't think we are, and we should, but are we really prepared to say that an individual fighter, whatever he thinks he's going to do with something, could turn that object into a military objective? I have great difficulty with the thought that an individual fighter could turn an entire building into a military objective. That's hugely problematic. I think if we could, the standard should be objectified, but that's a difficult task as well. So it could be that if you can reasonably expect that object to be used for military purposes, then that is something you can prove. Reasonable expectations is something we can work with, but it's still very difficult because there is a sliding scale problem here. Imagine the enemy has 3 roads, civilian roads, the main roads of the country. One is being used for military purposes. Now, if you attack it right from the start of the armed conflict, you can reasonably assume that your enemy is going to use road number 2 and then road number 3. And with reasonable expectation, you could, potentially, and this is the danger, argue from the start of the conflict, I'm just going to take out all 3 roads, because I know it's intended future use. Where do we draw the line here? I'm not so sure. We know. Tentative solutions. Very, very tentative. I think as I said, what we need to be looking for is more workable constraints than we presently have in the legal definition. And of course, this is a theoretical discussion. I'm discussing the law as it reads on the face of it. In operations, not all of this may be as problematic as it now seems, because there may be very effective policy, strategic considerations that of course keep the military from just using the entire potential of 52. It could be that you want to win the hearts and minds of your enemy, and therefore you leave the infrastructure intact. It could be that you want the infrastructure to be used after the war is over. This is, I think, what the US did to some degree in Iraq. They wanted to maintain military equipment to rebuild the Iraqi army. So there are different considerations at play. So not all of this plays out full throttle in practice, but it could, and this worries me. I would like the law to be much stricter. So, potential solutions. First of all, we could, by way of a theological reduction, interpret the effective contribution to be a significant contribution. We could use the argument that the more civilian it is, or to be more precise, the more important the civilian functions are that something is serving, the higher the threshold must be. I find that quite plausible. So we need to look for a more significant contribution if something is also making, simultaneously serving important civilian functions. We could also, with regard to dual-use objects that serve important civilian functions, we could do away with the purpose criterion altogether. I would love to see this. I don't think it's going to happen. But of course, hypothetically, I see reason in arguing that if it is an important dual-use object that really serves civilian functions, only if it is effectively and visibly right now in the present being used to serve military purposes can you attack this. To take it even further, and now to be a bit provocative, at least to some, if we agree with Chapter 9 of the DPH study, I know most states don't, but let's assume we did, and if indeed military necessity can be invoked as a restrictive element. Chapter 9 invokes military necessity as a restrictive element vis-à-vis persons. Capture rather than kill. I don't see why we can make a distinction then. If that is really true, if that's correct, I think it is. Most people think it's not, but I think it is. If that is correct, why does it only apply to persons? If there's a restrictive element in military necessity that works as a matter of law, which is disputed, but if it did, then why is capture rather than kill not the same for objects, where you would translate it into neutralize rather than destroy? The moment it is right now, there is no hors de combat or anything. Once an object qualifies as a legitimate military objective, you can destroy it completely. There is no limiting effects in the law. Again, policy considerations may keep you from doing this, but I find it very difficult to come up with any as a matter of law. And here, of course, you could bring in the restrictive military necessity function. If it is not necessary to destroy the thing completely, then it's not just a policy consideration. As a matter of law, as a matter of absence of military necessity, you must not destroy that object. You can neutralize it if you can, but you have to keep it intact. I think the difficulty in all of this is, and why it's pretty academic and just very tentative solutions, as I said, we see very little visible state practice, at least I do. You others may be seeing more military ICRC, but for academics, it's very difficult to come by any kind of coherent state practice that we could work with. So this is all up in the air. I think this would work and should be implemented, but I have no state practice to really back it up. The little state practice that I'm aware of usually only focuses on the facts and on the facts of proving whether something is used for military purposes. This is what it is about. Goldstone report, whichever incident, Afghanistan it is, it's about whether the facts prove that there was effective use, significant use for military action. I'll leave it there for 52, just a very few words on the related proportionality principle, because the two go hand in hand. Especially the definition of what an object really is, what we mean by an object, has huge implications for the proportionality principle. Because if you define the object broadly, you eliminate the proportionality constraint. Whereas if you limit the object, then all of what is not the object falls within the proportionality principle. Two examples. A big building compound, which houses the military, but also gives room to 1,000 civilian refugees. They are not there. It's not about the people being present. They're absent. It's just the functionality. This could serve 1,000 civilians as shelter. But it is also used by the military. Now, is this in its entirety a military objective? Or does it matter, does it in any way matter as a matter of law that it serves an important civilian function, serving as shelter for 1,000 civilians? I think we should draw a line here. I think this should matter. This functionality should come within the proportionality principle. But I fear, as a matter of law, as it stands now, as it is understood by states, the whole object qualifies as a military objective, and then you eliminate the proportionality principle. If we have an electricity grid, I think it's a more difficult scenario, because here the civilian functions the electricity grid is serving are externalized. So the example I had before was it's all in one building. Electricity power station, the power station may be used for military purposes and simultaneously for civilian purposes. That qualifies probably the entire power station as a military objective. But it has external functions for civilians, and this could be tens of thousands of civilians who rely on the power structure. I think here the readiness is greater to say that these external civilian functions feature within the proportionality principle. And I would certainly support that. They should, for all matters, be in the proportionality principle. Final 2 sentences. The problem you encounter here is they serve important civilian functions, but if you look at the proportionality principle, the only, as a matter of law, civilian damages that count is death, injury, and physical damage. At least that we don't know so sure, so this is the entry point. But it's damage to property, it's injury or death. Now, I would like to see a more broadly interpreted proportionality principle, where you can bring in the loss of functionality for so many civilians and for society at large, the economy, financial transactions, where you could bring in the loss of functionality as such within the proportionality requirement, without having to wait until someone dies because you took out the entire electricity grid. Thank you very much.
Our next speaker is Laurent Gisel, who is currently legal advisor in the ICRC. He's been working there since 1999. From 1999 until 2005, he carried out assignments in Israel and the occupied territories, Eritrea, Afghanistan, and Nepal. And from 2005 to 2008, he served as diplomatic advisor to the ICRC presidency. Since 2008, Laurent Gisel works at the ICRC legal division as legal advisor to the operations. From 2008 to 12, he covered notably the Western countries, Iraq and Afghanistan, and he's currently working in the Thematic Legal Advisors Unit. Prior to joining the ICRC, Laurent Gisel became attorney at law in Geneva and worked at the Public and Administrative Law Court at the Canton de Vaud. He holds a degree in law from the University of Geneva and a master in international law from the Graduate Institute of International Studies in Geneva. And Laurent will be speaking about the ICRC's, or an ICRC perspective, perhaps not the ICRC perspective, on current challenges with regard to the notion of military objectives. Go ahead.
Thank you.
20 minutes.
Thank you very much. Thank you to the organizers to have invited me to speak at this conference. I find the topic is extremely relevant and had been less discussed recently than the notion of the person who can be attacked, so it's very interesting to be here. I don't think that Robin made my task easier by all the questions he raised, because obviously I will have to defend the sheep clothing in Article 52 and say why it has a restrictive function, and not only how we could say that it doesn't have a restrictive function and then try to develop some innovative solution of how it could be, but that it does have now. I will offer a few examples possibly that for your consideration in that regard. One of them being, I will start with two preliminary remarks, then turn on Article 52 in particular and the two-prong elements that are so much discussed and criticized in a way, or their relevance put down by Robin, and then go to a number of type of objects, like a dual-use object as well, to offer some perspective, war-sustaining objects, and military medical objects, and I will tell you why in a minute. So the first remarks is that obviously the principle of distinction and concluding that that an object is a military objective is not sufficient to say that you can target it. You have other rules. We have mentioned the rule of proportionality, and I would say that probably some of the answers, if not all the answers to Robin's question, are also in that regard. In particular, when he said that the effective contribution needs to be significant, I would assume that if it is for purely military objects like a weapon, you don't care whether it's one single weapon and it's a military objective and nobody cares. And when it's for dual-use objects, yes, it is relevant, but then you have the principle of proportionality which comes into play and which might restrict your ability to target despite the fact that it's a lawful military objective. The second preliminary point is that, but that has been already mentioned, but the ICRC considered that Article 52 definition is customary for international and non-international armed conflict, so my remarks works for all type of armed conflict and all parties in those armed conflict, except if I mention it otherwise. So the two-pronged test. I think that Robin's remarks are very interesting, but we have to work with the text that we have, and saying that use, purpose, nature, location was meant to just cover everything and then in a way disregard it by saying if it makes an effective contribution to military action, it's enough. I'm not sure that's the case, and I will take the purpose criteria as an example. I agree with you that this is the most difficult criteria, objects which are military objective by their purpose, because what is the purpose and how you define the purpose. You mentioned that the ICRC commentary says that the purpose is defined as intended future use, and that's also taken up by other documents like the UK military manuals and certainly others. But that's still, for example, something different than potential use, because you need to have an intention to use it. You pretty well highlighted that the difficulty is to establish the intention and establish the intention of the opposing belligerent rather than your own intention, but that's still something different than any potential use. And the definition would have been different if you had only use, or if you had potential use, or if you had nothing at all, and the condition of in the circumstances ruling at the time within the first prong of the test. That would still all make the definition slightly different. Whether in practice, in operational practice, that would lead to other conclusion, that's a good question, but certainly in terms of, as a matter of flow, that would make a different definition, and we have to work with that definition. So the definite a military advantage, it's true that it has been, it's not very clear from the travaux préparatoires what is meant. The rapporteur of the working group said that a number of words have been proposed, and it's not even clear during the travaux préparatoires which word was chosen. You say we would like to see a significant. I would be happy if that's what is read in it. I'm not sure that this is the case. I think Israel said used clear military advantage to explain or give another illustration of what is a definite military advantage, but that's possibly something which needs to be explored as well. However, that's clear that it's hypothetical or speculative advantage cannot be taken into consideration if you have definite as a qualifier. So the fact that it's not entirely defined doesn't mean that it's useless, because it certainly excludes a number of things to be taken into consideration. I'm coming back just 1 second on the question of the purpose and Robin's point on whether it's the individual fighter or the party. I would probably say that it depends very much of the circumstances, and that you can have both depending on what type of objective you are talking about. If it's the highway being possibly turned into a military airfield, you might find that in legislation, in training of the military fighters being using the highway for that, and then therefore it's clearly the intended purpose of the party which will count. Now, if you know that an individual fighter or a group of fighters will tomorrow use a house as an ammunition depot, and they are still moving, they are already moving the stuff over there, I could say there is an argument to say that this is their intention to use that house as a command center, and even if it's not yet used, but they take steps to use it, that this counts even if the central government have nothing to do with that decision. So I think it will depend on the level of the objective you take into consideration to also see the intended purpose, I mean the intended use for the purpose criterion. The fact that the two prongs are cumulative, and whether or not they are all of the same or not. I agree with Robin that at least most of the case, they will be cumulative, or at least they will be cumulative if you include in the first one the in the circumstances ruling at the time criteria, which is only in the second part. So, but if you can merge like the first one plus in the circumstances ruling at the time, whether it really makes a difference or not, I will propose one example that actually you know already, so you might comment on, which is the internet infrastructure, which is probably can be commonly called dual used. It's certainly used by civilians, and it's used by the military for communication and transmitting order, command and control and communication. So it is used both by military and civilians at the same time, and that's what we usually refer to as dual use. And in that regard, it makes an effective contribution to military action because it's so much used for the military. Now, if you attack some part of the infrastructure, if you attack a cable or a router, an internet router, how does the system react? The system reacts that the data immediately, automatically, without you doing anything, without the parties losing any time, will just be rerouted through another part of the network, at least in most of the part of the network that you could attack. So I don't see any military advantage in destroying that a cable or a router if the only effect is that the data goes through another part of the network automatically. And in that regard, I think that's an example in which the first prong would be fulfilled, but not the second one, and which make me conclude that the internet infrastructure, in general, there might be a few exceptions, but in general, is not a military objective, despite of the fact that it does make an effective contribution to military action. Professor Hampson raised a very interesting point on the level of evidence required, and I agree with you that this is a matter which merits further discussion. You notably ask whether previous civilian use require more more different evidence with regard to current use. If you allow me to slightly reformulate the question and whether objects normally dedicated to civilian purposes require a different level of evidence than other objects, I think that the law gives a clearly positive answer to that because of the presumption that you have also mentioned. If doubt exists with regard to the military or civilian nature of objects which are normally dedicated to civilian purposes, they must be presumed to be protected against direct attack, according to 52.3. And I think in terms of the evidence, the level of evidence required, that must translate into a requirement which is higher to rebut this presumption as opposed to another type of objects. Now, and although we are stepping slightly aside from the notion of military objective, but with regard to person, I just want to comment on your question or your remark, Mike, on the 30% chance of OBL, Osama bin Laden, you will take it. And I'm not there is a presumption also for person and for all person, whether there is a doubt. So for me, I see it difficult to reconcile that with the presumption for person, because if you have a 70% presumption that the 70% chance that this person is not Osama bin Laden, then in my view, you still have a doubt. Otherwise, the presumption loses meaning. But I'm happy to listen more to you on that. With regard to doubt, some states, among them the UK, claim that the presumption is limited to situation of substantial doubt, but we don't feel that this is supported by the text of the first adhesion protocol. Expert meeting proposed the standard of reasonable doubt, and that seems to be much more in line with the law. Okay. Doubts, I think, is also linked with the question of force protection. Doubt can remain due to the impossibility to verify that a potential target is a military objective because of the risk that it would create to one's own troops. And of course, commanders have a duty under national law to protect their own soldiers, but such duty have to be applied in accordance with IHL, and for example, force protection concerns do not justify an indiscriminate attack. To come back to the question of doubt, it's the same. If doubt remains with regard to an object normally dedicated to civilian purposes, such object must presume to be protected against direct attack and either not be attacked or verification measures be taken even at the expense of higher risk to one's own troops. But it's not because there are risks that the attack can be carried out. Turning to certain categories of objects, and I will start with war-sustaining object. It's not a legal terminology, it's just wording used to encompass a number of objects, and as you certainly know, it appears in the definition of military objective of the US Commander Handbook on Naval Operation. Experts who drafted the San Remo manual, and I think you were among them? Okay, sorry for that. Discussed that and rejected this notion within the definition of military objective, and so does the ICRC. In our view, it's not sufficient to look at, and we come back to the question of the two-prong test. It's not sufficient to look at the second prong and claim that the object destruction would offer a military advantage. The first prong of the definition requires that the object makes an effective contribution to military action. If it merely contributes to the war-sustaining capabilities of the party to the conflict or its general war efforts, we do not see that as being an effective contribution to military action, and therefore we don't consider that it's a military objective. The same argument excludes attacking economic targets or objects of political or psychological importance because they would shape the cost-benefit analysis of the enemy more effectively than targeting military objective and then leading to a quicker end to the war. That cannot be taken into consideration in the definition of the military objective. Certainly, when among lawful military target. A state wants to prioritize which target to use through doctrines like effect-based operation or other things like this. It's perfectly legitimate to choose the objective which have the most effect, including on the will of the party. But in terms of defining the objective, it's not something you can take into consideration. Dual-use object. That's also a non-legal wording. I gave an example of one. I mean, they are usually considered to be legitimate military objective. I gave an example of one which is not. But I think it's important not to understand dual-use object as being meaning all such objects are military objective by definition. It's object that could possibly be military objective if in the case they meet the definition of Article 52, and that possibly can be used, also can retain a civilian use while they have military use or utility, but it's not that a dual-use object is by definition a military objective. I think it's relatively easy to discuss that when it's the current use of the dual-use object which makes it a military objective. If a tank is crossing a bridge, of course the bridge is a military objective. If a power station is supplying only the military barracks, it's also clear that it's a military objective, and it stopped being so when it stopped being so used. The problem is more difficult with the criterion of purpose, because actually that probably what is most important for dual-use objects is actually that they become military objective by purpose, and that's the case of bridges even before they might be used in view of their intended use. Now, some people put bridges and other transmission facilities, transportation facility, railway bridge in the military objective by nature. The ICRC does not believe that it's the case. Nature needs to be an inherent character, and it's basically military equipment. There is no military objective by nature in the circumstances ruling at the time. This is not something which is in the definition of 52, and again here I think the definition of 52 matters. We don't think that objective can be by nature in the circumstances ruling at the time. Nature is an intrinsic characteristic. Sorry. 2 minutes, I think I have, to talk about military medical object very quickly, and you might wonder why I talk about military medical object, because we all agree they are protected against direct attack, but I think it's an interesting subject to discuss under that heading because of the consequences it has for proportionality and precaution principles. The principle of precaution and, the principle of proportionality and most of the rules on precaution mention, as Robin recalled just before, death and injury to civilians and damage to civilian objects. And it has been argued in the literature that military medical personnel and objects are protected against direct attack. They are not protected under the principle of precaution and proportionality because they would not be civilian objects. In my view, at least in terms of treaty law, the matter is relatively easy for objects, and I concentrate on objects because that's the topic of the conference, even if I reach the same conclusion for person. But for object, I think it's easy as a matter of treaty law. Military medical object, transport unit, hospital, whatever, do not make an effective contribution to military action, and their destruction, neutralization, or capture does not bring a definite military advantage. Therefore, they are not military objective under Article 52.2. 52.1 say that any object which is not a military objective is a civilian object, all of them. And therefore, for the law on the conduct of hostilities, I understand that despite the ordinary meaning of the word, that medical military objects are actually civilian objects for the purpose of the law of the conduct of hostility, and therefore they are protected by the principle of proportionality and precaution. It's a bit more complicated for persons, but as I said, I stick to objects. Thank you very much.
And our third speaker is Advocate Pnina Baruch, who is Senior Research Fellow at the Israel Institute for National Security Studies. This is romantic. Advocate Sharvit Baruch retired in 2009 from the Israeli Defense Forces at the rank of colonel after serving for 20 years in the as an officer in the International Law Department, including 6 years heading the department. In this capacity, she has advised the IDF and government ministries on legal aspects relating to the laws of armed conflict, including on targeting, operational activities, counterterrorism operations, and occupation. She also served as legal advisor to the Israeli negotiation team in the Israeli-Palestinian track and the Israeli-Syria track in the peace negotiations during the years 1993 and 2009. Since retiring, Advocate Sharvit Baruch has been teaching international law at the Tel Aviv University and at the IDF National Security College. She has published several articles on issues relating to the laws of armed conflict and the laws of occupation. She holds an LLB magna cum laude and an LLM magna cum laude, both from Tel Aviv University, and she does everything together. And she will be speaking about military objectives and
No.
The practical
I'll tell you what I'm speaking.
Exactly. She'll tell you what she's going to be speaking about.
Okay. So first of all, thank you. Thank you for having me. It's an honor to be here. And what I will talk about is applying the principles of distinction and proportionality in uncertain cases, which I think we already started the evening with this question, and I will try to discuss some practical dilemmas coming from being a practitioner. I want to emphasize from the outset that I do not have definite answers, and I think Françoise also said it. I don't have exclamation marks. I don't have full stops. I mainly have question marks, and hopefully maybe by the end of tomorrow we'll have all the answers. So let me start. In order to crystallize the dilemma I want to discuss, let us talk about a hypothetical military operation, which will, for the purpose of my analysis, let us assume that the aim of the operation is the neutralization or destruction of a weapon system that is of crucial importance. We have here long-range missiles, and also to make things more easy for our analysis, let us also assume that no civilians are present, or not many civilians are present, so the main or the only relevant collateral damage would be to property. Now, I want to discuss two factual scenarios, two factual situations. The first one, we have the weapon system is stored inside a 4-story civilian building. In the second scenario, it is stored inside a compound, which includes 4 1-story structures that all are close to each other, and we have the compound. Now, I want to discuss these two are the two factual situations, and we have 2 scenarios. In the first one, the exact location of the weapon system is known, and in the second one, the exact location is unknown. Now, before going to the scenarios themselves, let us, and one last point, let us also assume that in both scenarios we have exhausted, especially in the second one, we have exhausted all means to gather more accurate intelligence, and that time is of essence. But I'll come back to that one. Now, as to the IHL, very briefly, we have, of course, the main principle. The first one is the principle of distinction. I won't repeat it, and you can all read it, but what is important for me to emphasize is that distinction is a binary principle. An object is either a military objective and therefore targetable, or a civilian object and therefore immune from intentional attack. Second important principle, of course, is the principle of proportionality, and we all know what that means. Here, what is important to note is that the principle of proportionality requires a balancing process. So it acknowledges a spectrum of possibilities and is more flexible. Now, the usual analysis in cases of targeting is 2-tiered. It begins with applying the principle of distinction. We have to determine that we have a military objective. Only once this requirement is fulfilled do we examine the applicability of the principle of proportionality, whether the collateral damage anticipated is not excessive or is excessive to the anticipated military advantage. And of course, there's also the precautions, which I will skip at the moment. Now, let's go immediately to the first scenario. In the first scenario, I remind you, the exact location of the weapon system is known. So we know exactly in which apartment it is, whether if we're talking about the building, or in which structure if we're talking about the compound. In this case, the legal analysis with regard to distinction is rather straightforward. We know exactly where the weapon system is. The weapon system is clearly a valid military objective. Therefore, we may attack the specific civilian apartment or structure in which it is stored. So we've satisfied that. We still now, next point is to check precautions. We have to take all feasible precautions in the choice of means and methods of attack with a view to avoiding or minimizing incidental harm. So if we have precise weapons available, we may have a legal obligation to use these weapons. There's a legal debate about that too, but I'm not going to enter into that here. But if we do not have precise weapons, we could still go ahead perhaps and target the weapon system, even if that means that the whole building or the whole structure will be damaged or destroyed. We have to then fulfill, of course, the principle of proportionality. We have to do the balance and see whether such destruction would be excessive to the military advantage of getting rid of this weapon system. So this is always a question mark, because it is relevant what situation are we. We have all the larger context that has relevance to the proportionality analysis. But this is the easy scenario. Let's go to the second one. When we don't know the exact location of the weapon system, let's start with the building. So we know that there is a very important weapon system in one of the apartments, but we don't know in which apartment. Does that fact mean that changed the result compared to the previous analysis? In the previous analysis, we said the weapon system is so important, let's say that we said that it is proportionate to destroy the whole building since we don't have precise weapons because of the importance of the weapon system. Does the fact that we don't know where the weapon system is change that result? Or in other words, can we view the entire building as a military objective? And I think, Robin, you spoke about that too. Here, the question is, of course, the relevant answer is in Article 52, which was just mentioned. And if we look at the definition of a military objective, in our case, the building is being used to store the weapon system, so it makes an effective contribution to the enemy's war efforts by virtue of use. The destruction of the weapon system offers a definite military advantage, and if the only way is to destroy it, in this case is to destroy the whole building, we are satisfying, I think, Article 52. On the other hand, we still have to check if we are not carrying out an indiscriminate attack, because indiscriminate attacks include those which are not directed at a specific military objective. So the next question we must ask ourselves is can we see the entire building as a specific military objective? Now, this is not a theoretical dilemma, because it is not uncommon to have general intelligence about the location of a military target inside a certain building without necessarily knowing the exact location inside the building. I think that in practice, commanders would tend to view the whole building as a military objective, and the focus of their dilemma would be on applying the principle of proportionality in such cases, and not so much on the principle of distinction, although from a legal point of view, this is not necessarily a clear-cut case. But now let's complicate things and go to our second factual situation. Now, again, we do not know exactly where the weapon system is, and now we are talking about 4 structures in a compound. And the question is, if we accept that the 4-story building is a military objective, one military objective, can we apply the same rationale with regard to the entire compound and attack all 4 structures? So, in an exercise that was carried out by the INSS together with the ICRC in a workshop a few months ago, most non-lawyers, we had a similar kind of scenario, and most non-lawyer participants tended to respond that in such a situation, the entire compound could be considered an eligible target for attack. And they focused mainly on proportionality. But does such an analysis conform to the existing applicable law? So the question that we address here, boom, is can we attack the whole compound? And again, the main question is this a specific military objective? Now, if we look at the plain reading of this requirement would lead us to say that targeting all 4 structures just because weapons are stored in one of them cannot be considered as directing an attack at a specific military objective. This is unlike the 4 floors of one building, which all form part of one structure. Is this, however, the only possible interpretation? In order to analyze this question, it is relevant to examine the underlying rationale of the principle of distinction, which is to prohibit indiscriminate attacks, which are defined in the commentary as attacks in which no distinction is made. The focus of the principle of a distinction, according to its historical background, is to prevent indiscriminate attacks which are intended to destroy civilian infrastructure without aiming at a military objective or gaining a military advantage, carpet bombing, for example. Attacking an entire compound in which a weapon system is housed is not an indiscriminate attack in this sense. Since a distinction is made, the object of the attack is specific, it's the weapon system, and not damaging the whole compound. So can we focus our interpretation on the intention of the attack and the purpose it is intended to achieve? The argument maybe would be that we shouldn't focus on the physical location, on the physical dimensions, but rather, again, on the question whether we have or not a specific objective. Now, and again, the rationale would be the difference is not specific, meaning a specific physical place, but specific in contrast with a general attack. A general attack is not allowed. A specific object that is attacked, even in such a few structures, a compound can still be considered a specific military objective. One of the concerns with adopting such a flexible approach to the principle of distinction is that this may result in viewing any single military objective located amidst a civilian area as justifying viewing the entire area as a military objective. For example, if there is a weapon system inside a village, the exact location of which is unknown, this could supposedly justify attacking the whole village. This would lead to the delusion of the principle of distinction and could eventually lead to its becoming meaningless. This is a genuine concern which must be addressed. In order to address this concern, I think that any flexing of the principle of distinction, if we decide that we can make some flexibility, should be limited by certain factors. For example, there must be a specific objective, like our weapon system in this scenario. And there should be some kind of territorial dimension, limited territorial dimension, maybe something like a compound, a campus-like facility, but not an entire village. Where do we draw the line? The answer, again, I think, would be the standard of reasonableness, the reasonable military commander. And of course, there may be other considerations and other factors. And of course, this question is, I'm not giving you a definite answer anyway, it is not an easy conclusion. But we also may look at the whole question from a different angle and ask a different question from an alternative perspective. What about if we don't look at all these 4 structures as one compound, as one military objective, but rather ask whether we can attack each civilian structure individually? Now, and here we are. In our scenario, in our analysis, we know that each one of these structures might contain the weapon system. So it is in one of them, but we don't know in which one. So this brings us to the article that was mentioned before, Article 52.3. In case of doubt whether an object which is normally dedicated to civilian purposes, when in doubt whether it is being used to make an effective contribution to military action, it should be presumed not to be so used. Now, while there is doubt about if this is a customary rule or not, it is agreed, I think, that in cases of doubt, a careful assessment must be made, and that a level of certainty as to the military nature of an object should be sought. Now, in our scenario, we have a 25% possibility with regard to each one of the structures that it is a military objective, and 75% that it is a civilian object. Because now we remember, we're looking at each structure separately. Again, our working assumption is that we cannot get any more intelligence, and that time is of essence. Okay, so we have to decide. The question is whether, in spite of a low, or relatively low, probability that a civilian structure is being used to store a weapon system, can it still be viewed as a military objective? Now, clearly, IHL does not require 100% certainty, but the question is, what is the legal threshold of certainty required in order to determine that an object which is civilian nature has indeed become a military objective? And of course, there is no magic number. But 25% certainty seems like a low percentage. So the conclusion could be low certainty, no distinction, none of these objects, none of these structures can be considered a military objective, so we cannot attack any of them. But the question is whether this is the only possible approach. An alternative approach to dealing with low certainty with regard to the status of an object is to substitute maybe the black and white binary determination under the principle of distinction with a more flexible evaluation under the principle of proportionality. In other words, such an object could still be considered a military objective, fulfilling the principle of distinction, but the low degree of certainty will be incorporated into the proportionality analysis, both with regard to the anticipated military advantage and to the collateral damage, the anticipated collateral damage. Thus, let us go to the formula. Thus, evaluating the anticipated military advantage, this is the formula, the AMA, would take into account both the value of the target, in other words, the extent of the military advantage gained by neutralizing or destroying the weapon system, as well as the level of certainty with regard to its status as a military objective. And I think, Mike, you were referring to this previously. In our scenario, the value of hitting the weapon system is very high. But with regard to each of the individual structures, the level of certainty is relatively low. In determining the anticipated military advantage of attacking such a structure, these two factors must be analyzed together, meaning that the value of the target will be decreased due to the uncertainty. Now, the collateral damage expected from the attack would be, of course, any damage to civilian objects due to the attack, including in the vicinity of the target. But, and this I think, Robin, you referred to this, I think part of the collateral damage can also be an estimate of the collateral damage occurring due to directing an attack towards an object that is not actually a military objective. In our case, if we attack the structure that is actually not housing the weapon, so we should take into account in our collateral damage assessment this probability. Or, in other words, the anticipated collateral damage would include, in a similar way like the anticipated military advantage, will include the value of the civilian object. So we will take into account, is it an empty shed, a residential building, a school, a clinic, together with the level of certainty that this is a civilian object and not a military objective. In our case, 75%. Now, if the anticipated collateral damage thus calculated is considered excessive to the anticipated military advantage, factoring in the element of uncertainty, then the attack could not be carried out. Applying this formula means that if the level of certainty about the military objective is low, then fulfillment of the principle of proportionality would only be possible in cases where the value of the target is very high and the anticipated collateral damage is very low. The application of the principle of proportionality in such cases allows us to apply a more flexible process instead of a black and white determination, which would be the result of ending the analysis with only the principle of distinction. Now, this might seem to you a very complicated process, and hence I'm sure you're all thinking, how would a military commander in a complex circumstances of an armed conflict apply such a formula? But this is a concern which I don't share. Keeping rules simple, and this I can tell you from my practical experience, keeping rules simple does not necessarily help when the circumstances are complicated. Rather, I believe that complex situations require complex solutions. Moreover, I think this formula, or something similar, at least this concept or approach represents the instinctive analysis commanders on the ground would make. The first question they would ask is, are there civilians around? That would be their first question, not the last question. And I even found in the ICRC research on practice an example. The example is from the Vietnam War, where a possible storage facility for where the US was considering there was a possible storage facility for air defense missiles, which would normally have been a high priority target, and it was removed by the US military from the target list because it was, and I'm quoting, in a heavily populated area on the edge of Hanoi, and the intelligence which indicated that it might be a storage facility was somewhat speculative. According to this passage, the target was not removed from the target list just because intelligence was speculative, but rather because of the combination of this factor and the fact that it was in a heavily populated area. In other words, the decision was not made on the basis of distinction alone, but within the principle of proportionality, because otherwise the civilians are not relevant. The main concern with regard to this suggestion is that blurring distinction and proportionality in such cases would eventually lead to the blurring of these concepts in general, leading to situations in which commanders will skip altogether the distinction stage and freely attack any object which might perhaps be regarded as a military objective, as long as the anticipated collateral damage is proportionate. Moreover, there will be no incentive to acquire more accurate intelligence on suspected targets, since they could be targeted anyhow. Such outcomes are, of course, problematic and should be avoided. I think the way to avoid them is that we have to have safeguards, and I think these safeguards apply in the obligations regarding precautions. And I think if I refer to Francois' presentation, she was also actually talking about precautions. Precautions mean that we have to gather intelligence. We have to verify the target. Only once all intelligence gathering has been exhausted would use of the suggested formula be allowed. I should also note that this formula is suitable, I think, mainly for civilian objects. I don't think this is a suitable formula when we talk about combatants and civilians, and here we have different rules with regarding to how do we deal with doubt, and I'm not discussing them here. In conclusion, let me reiterate my opening disclaimer. I am not purporting to suggest definite answers and clear-cut solutions to the dilemmas I have raised. My intention is first to present these dilemmas, which are based on practical experience, and secondly, to offer potential creative ideas as how to deal with them. I do believe in one underlying premise: the rules of IHL should align as much as possible with operational and moral logic. When they do not, the incentive of commanders to disregard such rules is high, and their confidence in the legal system is eroded. This outcome eventually weakens the effective application of IHL in the most complex situations when it is needed most. Thank you.
Thank you, Pnina. And I open the floor for questions. If you could just introduce yourselves. I need to go first.
Hello, Agnieszka Hechnio. I probably have a couple of comments to Robin about his comment about the definition. You said that there are two prongs that are basically the same thing seen from different perspectives. I take your point, but I disagree. I think the first prong relates to characteristics of the object, and the second prong relates to the benefits to the military operations. So they are, in my mind, not the same things, not necessarily the same things. And the perspectives also might be different. And an example of where the military advantage didn't benefit the attacker might be from Kosovo war, where the NATO was striking Serbian vehicles in Kosovo, and the military advantage was benefiting Kosovo Liberation Army on the ground rather than NATO itself. That, at least in my opinion, but can be disputed. Then you said that use or effective contribution to military action has to be visible. I don't know whether there is a legal requirement of its being visible. I agree it has to be current use, but that's based on interpretation of the definition of the meaning of the term rather than actually being written in the definition. And when you said that the sniper was on the building, which object we're seeing, I think the questions might be answered more through the practicalities of the operations, where the military would probably use a bullet point to take the sniper rather than drop a bomb on the whole building. And the issue then goes away, because then clearly the threat is being removed by neutralizing the sniper. Thank you.
We'll take a collection of questions. We'll be, and then
Yeah, I'll revisit that. Just a quick, sorry. Yeah. Thanks very much. Just a quick question to Robin. It sort of follows, I think, from the last point. It's about the link, sort of on your restrictive or the approach that you're suggesting to the destruction, capture, neutralization, and the link between that and the notion of definite military advantage. That is to say, can you envision situations where the military advantage would be greater, obviously, if you were to destroy rather than neutralize, but even the neutralization would pass a threshold of definite military advantage? Would these be the only scenarios where you'd suggest to opt for neutralization? Or would you say that if neutralization doesn't cross the threshold, but you don't want to allow destruction, you actually need to avoid attacking entirely? Thanks.
Thanks. My question is for Pnina. Well, I suppose it's more of a comment than a question. You were describing the reasons that people might resist this idea that you advanced about the formula that you presented. And I think there's something, though, reasons to resist beyond what you were implying, the sort of idea of this fear of a slippery slope of abuse or misuse by operational commanders when you expand the degree of discretion that they have. You also mentioned moral logic, and that the reading of the law has to be based on it. And I think the moral logic of the law goes beyond those kinds of considerations, and it offers another reason to resist that. I think within the law, when it establishes a prohibition on attacking certain categories, civilians, and civilian objects, the idea is that those things are absolutely not allowed for. There's something morally abhorrent about directing an attack at a civilian knowing that you're doing that. And in the example you were presenting, in 3 of the 4 cases, that's what you're doing. And I think so. I don't think it's not just a question of abuse or misuse or slippery slope. It's actually violating a sort of, a core principle there. It's something that's a sort of red line that's articulated in the law. And I think there are reasons, to resist beyond that. I mean, of course, the other reasons, I do think also when the law tries to establish these sort of black and white rules that you were describing, yes, then you get the complicated cases. But when the law says when in doubt, don't shoot, now what you're saying is sort of when in doubt, start calculating, you can understand why. I think that's very convincing for people who have a lot of faith in the people doing the calculating. So the operational commanders who will be doing that. For the rest of us, and those other concerns that you were describing are quite real, because there's a limit to how much we're willing actually to allow discretion to be passed over to others.
There's other people waiting to ask, but I suggested maybe we take this first shot before the audience forgets the original questions, and then we'll take another round. And I've got the gentleman in the back, and Ken, and Eliav and Mike written down, waiting for your turn. So.
I tend to have that problem about forgetting the questions too after an overnight flight, so sorry, I'll try. Does it need to be visible? No. I just wanted to give a very clear-cut example where it is even visible, so it's very straightforward. You're right on that. Is it the characteristics in the first prong and the benefits in the second? There's all kinds of attempts to frame this in one way and to get that distinction in the two prongs. Some people say the first test is objective, the second subjective. Some say the first is entirely abstract and the second is contextual. There are all these attempts. As a matter of fact, in all practical purposes, I think what I said remains true. They usually play out the same, no matter what label you give to either of them. And that is the problem that I have. Same with the sniper. Certainly, of course, it's easier to just focus on the sniper, even though, be careful, this is human life and object, so it's not so straightforward. But of course, the military would probably target the sniper, not the entire building. My problem is that even though this is what operationally is likely to happen, the law, as it is currently interpreted, for most purposes, would allow to attack the entire building. And this is my problem, and I don't want the law to allow that the entire building can be attacked. Brings me to military necessity. I'm afraid I didn't fully understood the whole question, but I think, would I limit it to neutralization only? No, I think military necessity is your best port of call if you want to say, in an object like Pnina had here, the one window where you have the weapon system, military necessity is the legal rationale why you cannot destroy the entire building, why you only have to focus on what you really need to destroy for military purposes. This is your best bet to bring in a restriction in these compounds and larger structures. So I would say if there's no necessity to destroy it completely, then you have to neutralize as far as military demands require. In Pnina's example, that would be that one apartment where the weapon system is, but not the entire large compound with all civilian structures.
I agree that attacking a civilian object is apart from it being illegal would also have a moral flaw, and that's part of the rationale, the whole rationale of the IHN. So I'm not talking about attacking a purely civilian object. The question is that I was trying to answer is, what do you do when you're not sure? The question is really, how do you deal with doubt? And if there is no doubt that it is a civilian object, clearly you cannot target it. Even if you have, even if it gives you, and that was explained before, some general military advantage, it's not a military objective. The main question is the doubt, and since we don't have in any case a clear defining line, when does it still be considered a civilian object, when does it become a military objective? So I'm saying, since in any case there's no definite line, so in order to give an answer, there is we need to or we can maybe use notions of a spectrum. Now here again, what will come, and here I think what I try to add is not only because before, when we were talking about, when Mike was discussing the presentation of Francois, he was saying what is relevant is the value of the target and the certainty and the level of certainty. That's with regard to the military advantage. But I think we can also look at the civilian object, the value of the civilian object, and the certainty or that it is indeed civilian. And if we put all that into the equation, I think eventually we will reach a result which is moral. I don't think in that if we go beyond, if we go into these kinds of equations and balancing processes, we would necessarily do something immoral, because again we have to have some kind of military objective, and we have to have some kind of doubt. We're not talking about purely civilian objects, and I think, just to answer Robin, I think that if I have a sniper and the only way to get him is to get the whole building, I think it, even though you say, okay, if it's a military objective, we don't calculate it into collateral damage, I'm not sure I wouldn't question that. I think if we have a civilian building and there a valid military objective like the sniper, but the only way to get him is to get the whole building, we can perhaps take, even if we say the only way to do this is by seeing the whole building as a military objective, still it can also be relevant to see it as a part of the collateral damage. So I'm not necessarily sure that anything that is deemed a military objective and therefore targetable will necessarily be excluded from the collateral damage assessment.
We'll take a second round of questions. The gentleman in the back.
My name is Advocate Morganston, and my question is for Advocate Sharvit Baruch, and I'd like to try to help you to clarify your flexible application principle for the audience by giving you an example, I think a real example. The last incursion of the IDF into Gaza, I believe that under the hospital called Shifa Hospital, is it? You had the Hamas command post. In other words, we'll take that as a given, that the entire command of the Hamas was below the hospital. What's your call on that one? Using your principle, of course.
Should I answer? Or should we let's take a round of questions? We've got.
It's Ken Watkin. Pnina, as I understand your theory, to get there you have to really, you're doubting the utility of the principle of distinction. And it seems that way. So I guess maybe if you could explain more how the principle of distinction survives this, or at what point in your theory it gets reintroduced if it's an important principle, which I think most people would suggest it's fundamental. And I guess the other question that comes from this is that as I listened to your example about speculation in Vietnam, I tried to put a percentage value on that target. And I just wonder, human nature is to run to a percentage with difficult decisions or difficult questions. And certainly Mike's example of that, 30%. But speculation, I'm just trying to understand where in this formula, where the staff, before they took it to the commander, of what percentage they would give a speculative target. And I guess if the speculation was 1%, would they still take it forward? And would that be seen a waste of the commander's time? Or at what point at the staff level would they decide they reached a level which would allow you to do that? And so ultimately what seems to be lurking in this discussion is what, and I think in the discussion in the previous panel, was the question of doubt. That the Galich case, as I recall, said reasonable doubt would be a test that would be considered, which allows for an honest but mistaken belief. But I just wonder how reasonable doubt in the 4 buildings, if you had a reasonable doubt that the missile wasn't in 3 of the buildings, how you would justify a strike at that point. I'm still not clear of what level of doubt you have with your analysis that would justify launching the attack.
Yes. Well, I'll start with the hospital. The hospital can be a military objective. The headquarters of the Hamas was indeed in the Shifa hospital, but and of course, there's a special protection. You need to give a first warning to stop using the hospital for military military use, and only after that you may attack a hospital if it is used for military purposes. So potentially, maybe, and that's not. There was no doubt there, so it's not so much what I was discussing. In such a case, perhaps it could have been viewed as a military objective. The reasons for not attacking the hospital went beyond just legal considerations, but there was not really a doubt. I said in the beginning, the first heading I had was the relations, or it still is the relations between distinction and proportionality. And in the beginning I said, yes, maybe we should add proportionality into distinction. And very quickly I came to the conclusion that's a very bad idea. I think the 2 principles must be separated, and I think we cannot skip over distinction. So I'm not trying to do that, but I am trying to say, what do we do when the distinction, when we have doubt with regard to the distinction? And the question is, in such cases, I know something is within 4 structures. I don't know in which one. Does the fact, and it's a very important weapon system, for example, do I have to stop there? Because if I haven't fulfilled distinction, I cannot attack the target. Or can I check what would be the collateral damage? What would be the damage to civilians, to civilian objects? And if the damage, the collateral damage, including the damage to 3 of the 4 objects, 3 of the 4 structures, is taken into account into the collateral assessment too, would be low compared to the military advantages I have here, a case of doubt, can I still go ahead? Meaning, can I move from distinction to proportionality? Now, it's not. I admit that what I'm suggesting is not easy because it's a very fine line between being flexible in one way and then becoming skipping the distinction altogether. And I don't think distinction should be skipped. I think it's crucial. But I think that these dilemmas exist and that we need to give good answers to these dilemmas. Either see it as one military objective or have the doubt enter somehow into the calculation, including the proportionality, because I can tell you that in fact, the commanders would not even understand what is the problem if you have these 4 structures, there's no civilian around. What the hell does the military advisor want them to do? Not attack and get rid of this weapon system because maybe it's an empty civilian shed. So I understand that we don't want, and I'm the last one that wants not to have the line between distinction and proportionality. Distinction is crucial, and without distinction, only proportionality, that I think will be the end of IHL. So I'm not suggesting that. I do think that we have to find ways to give answers to these situations, because these situations of doubt exist, and we need to have practical solutions. Maybe the answer is no, you can't do anything, that's it, perhaps. But I'm not sure that at least we shouldn't explore possibilities and maybe reach that conclusion in the end.
Robin, you want to answer?
Just briefly, because I thought the legal uncertainty issue, Ken's question and also David's example is right to the point. With 3 hours in the panel, and pretty much every speaker, me included, has said 25 times that operational context matters, it's all reasonableness, depends on the circumstances. We have to be very careful where the circumstances come in. Because here we're not in the battlefield, this is a very abstract academic exercise, we're doing a line drawing exercise, and if we're talking about the rule as such, the rule is not dependent on circumstances, it's the application of the rule that may be circumstances specific, but not the rule as such. If it is, then it becomes a rule of thumb, and that's not going to work. That's not law, that's pure reasonableness. And I had a feeling this is where the military side is trying to go. I certainly would not want to go down that road. And just one more sentence on that, in David's example, 95%. I think if we adhere to the law, 52 requires you to know. You cannot not know, you cannot be unsure. You need to know this is a military objective, and then you need to confirm. And it may be that for feasibility reasons you cannot confirm, but you need to know. Otherwise, you're attacking into the blue. So my answer to your scenario would be, you can't. 95% is not good enough. You need to know 100%.
You need 100%.
And then you confirm.
That's
and this
world
is,
peace.
And this is also, I think, what Françoise... I think this is, in a way, what Françoise also said in her presentation. Because if 57 is about confirmation, what are you confirming? The thing you don't know? I mean, you must know, and then you confirm. And you need not only confirm, need not always confirm, but you need to know. 52 doesn't allow you any doubt. 52 says it makes an effective contribution to military action. It doesn't say, well, 95%, 80%. You need
What's
to know.
the ICRC position?
That's the law. I agree that states have interpreted this differently. I know it's handled differently, but if we're true to the law, I think this is what we need to do.
Eliav, and then Mike before you explain.
Hi, Eliav Lieblich from IDC. This is to Robin, perhaps also to Laurent. You mentioned the famous or infamous Chapter 9 of the DPH guidance as applicable in some way to military objectives, and I was wondering to what extent are you willing to draw from the other aspects of the guidance to the question of military objectives, especially, for instance, I'm thinking about continuous combat function, whether an objective, if it is used repeatedly for military purposes, does that change the nature of the objective in a matter that affects the temporal scope of its targetability, for instance? Right, just something I was thinking about.
Yeah.
Mike?
Robin, I have to compliment you. I mean, never has anyone made a more effective transition into academia than you. So well done, well done. Listen, I have to just respond quickly to your last point. That's absolutely ridiculous. That you would have absolute, I mean, seriously, Robin, that you would have absolute knowledge. You know, the good thing is if that was the rule, there would almost be no war. So, I mean, I support the rule in theory, but not in practice. That's simply not realistic. I also, on a more serious note, Robin, I was very interested in your effective contribution military advantage, because I've never heard anyone make this assertion before. The assertion is always made in the context of the U.S. position vis-a-vis nature. Military objects by nature, that they're sort of one and the same because it's a military object. But with regard to the others, I have to stick with Agnieszka and Laurent here. I certainly can come up with many examples. Agnieszka hit the nail on the head. Effective contribution is about the military character of a proposed target, whereas military advantage is about its value. So it's interesting, and you know, it would resonate in Texas, where I'm from, but I don't think that's the law. Laurent, you asked me a question with regard to doubt. First of all, I would very quickly point out that you're talking about doubt in the context of the additional protocol, okay? And as you know, the customary nature of that particular provision is not settled vis-a-vis objects. One country, a particular country, says that that is a provision which applies only as a matter of treaty law. And we found as much in the AW manual, acknowledged that, as well as in the Tallinn manual. But if it was customary law, and I happen to think it is, by the way, but if it was customary law, the answer is that it's reasonable doubt. That's perfectly acceptable. The problem that's often made is people say if there's any doubt, then you can't act. That's not true at all. It's exactly as Pnina said. Doubt in the circumstances based on the value of the target, et cetera, et cetera, et cetera. This is well settled in international law. And finally, I have to comment on your scenario, Pnina, because I thought it was easier than you made it, although I loved the approach. Because the military objective is the missile and the building that it's housed in, whatever building that is. You don't need to know what building it's in. Why? Because you can engage in target area bombing. Now, before everyone chokes, remember that target area bombing is recognized in Article 51.5. It says if you have clearly separate and distinct, et cetera, et cetera. So what you say is, it's just like a bad guy in a forest. I've got a target. I've got a legitimate military objective. It's somewhere around there. I can't figure out exactly where it is, so I'm going to apply that method and means of warfare that will allow me to destroy that target. However, the real issue is proportionality. And there, the proportionality is exactly as you say. I mean, I know that there are 3 buildings. Whichever 3 I know, there are 3 buildings that were civilian, so then I do that.
Françoise? And then we'll take last answers.
A couple of comments in relation to Robin and then a question for Pnina. First, if you like the good news, I think you've already got a bit of law that would help you on some aspects of destruction, and that's the prohibition of wanton destruction. Mm-hmm. It seems to me that that means if it's not necessary, you're going to have a problem escaping that. Aren't you forgetting that in both cases, you've got to have an effective contribution to military action, an effective military advantage, and that does act as a restraining element. In relation to, and by the way, can I object to what Mike said about academics? In relation to what Pnina said, what's really interesting there is the nature of the doubt in your scenarios. You have no doubt as to the existence of the missile in that general location. Your only doubt is precisely where. What would have been the position in scenario 3, where you think there may be a missile, but you don't actually know that there is one? That's a different kind of doubt.
Okay, Mike, I don't trust you on this, and that is the problem. Everybody keeps maintaining I have many examples and two-prong works very nicely, and this is exactly my problem. In most practical circumstances, it doesn't seem to work so nicely. It doesn't seem to work as an effective constraint. So I wasn't saying that I'm in favor that we just look for effective action and that's it. If the two-prong works, I'm all for it. But I don't trust you. I don't think it works so well. And I don't think you have very many examples that would really be very, very convincing and limiting, or where, to be more precise, the attacker could not argue his way around if it was shaky. And that is my problem. The law is not as robust as it should be. And I think academics are there to deconstruct common wisdom, and that's what I'm trying to do, and otherwise it would be no fun having me speaking here because I have no operational knowledge, so what do you want with me? François, I totally agree it is about effective military contribution, and there is constraint in that. I only wanted to say I want to see slightly more constraint, but absolutely, and maybe, I mean, states seem to accept this, and maybe this is it, and then that is okay. What I wanted to answer to you, yes, sorry, I'm a bit slow. Today, would I want to use other aspects of the DPH study also for military objectives? I don't think so. Not because a categorical no, but because I think there's a difference between objects and persons. Persons, we really have distinction. We really have groups that stay in their group. If you have a continuous combat function, if you are a combatant, part of the armed forces, then you can be targeted at all times. We're much more flexible with military objectives, and therefore I don't think that the continuous combat function rationale has any real effect on military objectives. There is really a difference between the two.
A few points on your presentation, Pnina, and on the compound first. And I think it's, in my view, it's clear that the compound cannot be the objective. The question, I think, was correctly reframed by Mike. It's the precision of where you know it, but the fact that you don't know it doesn't make the compound the objective. It's, in a way, putting the right question. The compound cannot be an objective because there is something in the compound. The question is, with what precision of location do you need to know where the thing is before targeting the thing? But the objective that you target is the weapon system. It's not the compound. Neutralization and destruction, another point to that, but I agree that it works better for civilians as opposed to only damage to object, is the obligation to take all feasible precaution in the choice of means and methods to avoid incidental harm to civilians. And if you take that example and you still have a few civilians in the building, and you could neutralize rather than destroy the target, and through that avoid the civilian casualties, certainly you have to do it already today. So you have some cases where you have to neutralize rather than destroy. It's true that with the question of object and the fact that the entire object becomes a military objective when it's used, or at least that's how it's often understood today, it creates more of a problem. But I find your suggestion that even the civilian part of the object remains civilians and remain counted in the proportionality equation, of course, is very appealing, and I would tend to agree with it. I don't know that it's how it's shared today and understood by states, but that's certainly something I would tend to see favorably. On the Chapter 9 and the DPH guidance, as you said, repeated use, I would go back to the definition and say, as such, repeated use, no. But if you can infer from repeated use that it's intended that it will continue to be used, then you fall on the purpose, and then yes. And that's built in Article 52. But then you have to take overall all the circumstances, and if you can reasonably believe that yes, the enemy intend to continue using it that way, and the fact that it has been repeated use is certainly a strong element in that assessment. And that brings me to the reasonable question, and I agree with Mike that 100% is not required, and that's not how it has been ever understood.
That means I don't know he is a military target, but I'm going to attack him. That's what it means.
I don't know for sure. I don't know for sure. I think. Yeah. I have reasonable belief.
What is absolute knowledge?
Absolute knowledge
Even judges don't have
doesn't work in war. And Ken, you mentioned that Galich said reasonable doubt or the reasonable commander, and that's what you mentioned as well. But I think that's, and I had mentioned in the presentation, that the standard which is generally acceptable and accepted, but then that probably doesn't solve all the question, because then I disagree with your understanding of what is a reasonable doubt. Because if, to take figures, it's 70% is a reasonable doubt, not in my view, and I'm not sure that, I mean, if it's reasonable in view of the target or in view of the overall circumstances, I think that's a good question. One thing that struggles me is that you use reasonable doubt also in another situation, and in a way everybody agrees that this is not the standards of the reasonable commander, but we still speak of beyond reasonable doubt. That's in judicial proceedings, and it's the exact same words. Nevertheless, everybody agrees that it's a different standard because that's an unworkable standard for operations. So what is then the reasonable doubt standards of the military operations? I don't know, but I certainly disagree with the fact that it would be below more likely than not, because 30% is less, it's not even more likely than not. And that this would be a reasonable understanding of the reasonable doubt. I disagree with you on that point.
First of all, I agree. The target is the weapon system. The question is how do you define, and I think Oben also spoke, how do you define the military objective or the geographical or physical dimensions of what can you attack? And target area bombing deals again when you have several military objectives and you have civilian objects within them, which is not exactly the situation here, because here you have a military objective, you don't know exactly where it is. So it could be an analogy, but I'm not sure it solves exactly the question. I think Francois, your question actually clarifies maybe a little bit what I wanted to say, because exactly the difference is if the doubt is whether the weapon is there or not, then I think the general framework of when we talk about doubt is you need to have reasonable belief that it is there, or if you have reasonable doubt you cannot attack with regard to the fact whether there's a weapon there at all. What I was focusing is on the situation where you know that there is the weapon, and it's more, the question is more of what is the extent of the area that you can attack. And here I thought, so one way is again to look, for example, the whole compound as one military objective, but then the objection to that could be, okay, where do you draw the line geographically? And another one would be in such cases where you know that it is there, you just don't know exactly where, is to have this doubt incorporated into the formula. But I'm not suggesting that any case of doubt as to whether it is there's a weapon there at all would also be factored through this kind of formula.
Well, if I had to summarize this part of the conference, and I guess I should summarize this part of the conference at this point, I'd say that if Francois started a presentation by saying, let's assume that she assumes that we know what the definition is of military objectives, and queried what would be the test to determine that, then I think Robin it started out with saying that no, we actually don't know what a military objective is. And if Laurent offered some answers to that, then I think it's fascinating that Pnina indicated that in the maths of the laws of armed conflict, 4 times 1 is not the same as 1 times 4. So I don't think it could get any vaguer than that. So I hope everybody joins us tomorrow for some greater clarity, or not. But before that, please join me in thanking our speakers.